All right, welcome back. Our next panel is called Cyberattacks on the Supply Chain, Incident Response Strategies, and we have a great three-person panel. First, I'd like to introduce Wim Nauwelaerts. He's the partner in charge of Alston & Bird's Brussels office and leader of their European privacy, cyber, and data strategy team. He has almost 25 years of experience working with global companies on their data protection, privacy, and cybersecurity needs, including GDPR readiness, data transfer, data security, and breach requirements and compliance training. Welcome, Wim.
Thank you, Bruce.
Next, let me introduce Jarno Vanto, a partner with King & Spalding in their New York office. He's in the firm's data privacy and security practice. Due to his extensive international regulatory experience, he's frequently called upon by his clients to provide the global perspective regarding privacy and cybersecurity, corporate and technology-related matters. And his experience spans the full scope of privacy laws, including GDPR and CCPA. Welcome, Jarno.
Thank you very much, Bruce.
Finally, very pleased to welcome our moderator, James Lloyd. James is a partner at Latham and Watkins based in London. He's an experienced litigator and investigations lawyer who represents clients on cybersecurity and privacy-related matters, including regulatory and internal investigations, incident response, and cybersecurity resiliency. James leads responses to significant enforcement investigations by international and domestic regulators, including the UK's Information Commissioner's Office, law enforcement agencies, and parliamentary select committees. Welcome, James.
Thanks, Bruce. Good to be here.
Let me turn it over to you.
Thank you very much, and welcome everyone to our panel, our little panel. I doubt anybody attending this session necessarily needs convincing about the threat posed by cyber attacks on the supply chain. It's certainly nothing new. Folks in the security industry have been describing it as a challenge for a very long time, but perhaps with some limited success in prioritizing it as a risk. SolarWinds, of course, certainly acted as a catalyst and a wake-up call about that risk to everybody, from businesses to government. And we saw a bunch of guidance on the legal side issued in its wake and a heap of investment in cybersecurity from businesses. But to what extent has all that attention driven better incident response results? So the three of us are going to share today our experience of supply chain attacks in the past 12 months and beyond, and the unique challenges that those incidents present to a business, including those beyond the initial frantic attempts to figure out what went wrong and how to fix it. That said, figuring out what went wrong and how to fix it is always going to be front and center to any successful response to an incident. And to do that, you need to gather information, things like root cause, what the attacker did in systems, and especially from the legal side, what data was impacted, if any. Now, that's one thing where you're the party targeted by an attack, but when it's in your supply chain, that's quite another. So, Jarno, if I can bring you in first, perhaps, can you tell us a little bit about the issues that you've come across when acting for a customer, perhaps, whose supplier has suffered an attack?
Yeah, obviously, industries have their own attack surfaces, so to speak, and we're impacted in different ways by different suppliers. So if you're in the software supplier space, for example, then that may cause harm to your own systems. And then if you're in the sort of data processing, data analytics environment, then your vendor may expose your personal data. And then if you're in the, for example, automotive or other hardware space, that includes software components that may not only have information security implications, but then also safety and implications to your end customers. But all of these have sort of one common denominator is to how to build trust as you're building the relationship with the vendor. If you have legacy vendors that you've been engaged with for quite some time, maybe to reassess their relationship based on cybersecurity and information security obligations. But then if you're engaging new vendors, really what it comes down to is that if there's no signal of trust and openness as you're building the relationship, maybe it's not worth going into that relationship to begin with. But then there are particular challenges, obviously, with respect to regulated data that may be exposed as a consequence of a supply chain security issue. And then we're dealing with deadlines on notifications. And if you don't have that awareness on the supplier side about notifying you, then obviously you might be in breach of your own applications. And again, it depends on the industry around the personal data that may be exposed, other data sets that may be exposed, and your regulatory obligations to notify. And so it's a complex set of issues, but again, it's about building trust in the beginning of the relationship. And if you have long-standing relationships, reassessing the basis of cybersecurity obligations, that is critical.
Yeah, very interesting. I think you've hit the nail on the head in terms of trust and goodwill from the outset. Of course, it doesn't necessarily last during those tense conditions on an incident, but maybe we can return to that in a minute. Wim, what about you? Same question. So, what sort of issues have you come across?
Yeah, just to add to what Jarno was saying, James, suppliers are typically in a processor role, right? And at least from a GDPR perspective, processors are required to assist and inform the controller when there is a personal data breach. But we are seeing that sometimes, controllers are not notified in timely fashion. That can create regulatory issues for the controller. For example, the controller can be fined for late notification. And also, often the processor provides very little information up front, right? Also, potentially problematic for the controller because, as a controller, how do you assess, whether or not you need to notify the regulator, affected individuals, if you have very little information to go on? And some regulators will encourage provisional notification, but again, I think we all agree that is not always ideal. And then there's the other side of the spectrum, which are the suppliers that over communicate in the case of a breach, right? Again, the principle being here that they should not communicate as processors about a personal data breach unless the controller agrees. But again, in practice, we're seeing that some suppliers will even notify regulators themselves before the controllers are aware of the breach, right? Or sometimes immediately notify affected individuals, either individually or through some form of public statement, which is obviously the worst possible scenario, because if you're in the controller's position, it's very difficult to put that toothpaste back into the tube. So there's a risk that controllers lose control over the whole notification process, and that is a risk that needs to be properly managed. James, I recently had a case where a supplier immediately reported a breach to the regulator because it considered itself a controller for very limited personal data that was involved in the breach, but it really didn't leave the customers any other option than also reach out to the regulators and notify this incident. So, I think it's crucial to coordinate with the suppliers, preferably before an actual breach occurs, and really determine who is going to communicate to whom and about what, right? Because, if you get it wrong, there's the reputational damage, the commercial damage, not just from I would say, controller side, increasingly also from a supplier side. And obviously the regulatory scrutiny and potential fines, administrative fines or other sanctions, which in the past, again, were focused mostly on controllers, but we are seeing increasingly that also now processors are in scope of these type of sanctions imposed by data protection regulators.
Definitely. Yeah. I mean, it's that classic problem of too many cooks, isn't it? So, at this time when you want to be controlling a narrative about something very sensitive, and at a time when, frankly, you don't have enough information, suddenly you've got an extra player, or at least one extra player, who is particularly active. It's kind of the last thing that you want. Jarno, have you come across that at all? Have you got any thoughts on how you can sort of shut folks down before they go crying off to regulators or making things worse?
Well, I'm kind of continuing in the theme that Wim started there, which is communication. Obviously, you don't want to communicate with your supplier only in the instance of a breach, so particularly with respect to critical supplier relationships. Regular cadence of communications between the supplier team and the customer team is critical. For example, the example that Wim mentioned about the processor notifying regulators, again, it would have been probably helpful if there had been, issues about awareness of an incident would have been discussed before these notices go out. And again, it all comes to communicating.
Yeah, 100%. So, yeah, fundamentally, we've got sometimes problems getting information, certainly information that we need to make regulatory notifications, and in some cases, problems controlling the narrative. But really, as you said, it stems towards a lack of control and good communication. In terms of strategies for dealing with uncooperative and unhelpful suppliers, perhaps beyond communication, what are your thoughts on sort of legal remedies, and to what extent have you relied on those during active incidents? Jarno or Wim, would you like to take that first?
Perhaps I could get started on that, and particularly indemnity obligations are becoming key, at least on this side of the Atlantic, when it comes to handling potential fallout from incidents, and for example, reporting obligations and state AG notification obligations and other potential consequences of an incident, and how the supplier then may indemnify in connection with such incidents. So that's really a key issue here. Another aspect of this is that the initial building of the relationship when you're negotiating supplier agreement, obviously, the potential consequences must be clear to the customer in terms of what the outcome may be in serious supplier incident scenarios, and both parties should be sort of have a healthy understanding of the potential risks involved, but then also understanding what the insurance coverage of the supplier is in the event of an incident, and making sure that the caps of the coverage are appropriate in respect to the risk that's being assumed.
Yeah, I think it's a really tricky situation as well. I'd be interested, Wim, in your thoughts, just in terms of where you do have an uncooperative supplier, and you need things like artifacts and IoTs and just other what you might consider just basic information for the purposes of reassuring yourself that your systems aren't compromised, in terms both for that, whether data has been taken, firewall logs, whatever it takes. If your supplier is simply saying no or giving you limited information, or certainly in my experience sometimes wrong information, then that can put you in a very difficult position.
But James, I think that comes down to really the kind of the openness that we discussed in the beginning. If there's already signals as you're building a relationship that they're not open, for example, with software vendors, if they're not willing to discuss whether their development environment is secure, other types of security considerations are not willingly discussed, then that's probably an issue, and we can anticipate that there will be issues in connection with an actual incident about providing, for example, appropriate information.
Yeah.
Yeah, James, and I think also the problem is if you are dealing with a supplier that's not willing to play ball, it's not providing you with that critical information that you need, unfortunately, the regulators don't care, right? I mean, it's your problem. So It's not an excuse to say, oh, but I'm sorry, I mean, my filing is incomplete, or I didn't file on time because I didn't get the information from my supplier. That's not going to buy you any credit with regulators, at least not in Europe.
Yeah. Yeah, very true. And indeed, there could be some pretty serious consequences if, in the case of those overactive suppliers, they've already gone ahead and notified, and suddenly you're deciding whether or not you should have done it earlier, or whether you should do it at all, right?
Yeah, exactly. And look, having remedy provisions is one thing, but if the harm is done, it's done, right? So I'd rather put my bets on prevention.
Yeah, absolutely. I think, in a lot of ways, what we're talking about is preparedness, but in a different, I know we spoke about this before this session, but it's preparedness in a somewhat different sense to what we normally discuss at the IR forum. So it's broader than, just planning and practicing your IR plan or running tabletops. It's about getting buy-in from across the business so that the business has the tools it needs when the worst happens. And by tools, and I mean that in the broadest sense. So, the right contractual provisions and the right commercial sensitivities and trust and goodwill that Jarno's described so well. I was certainly involved in a big supply chain breach over the summer where that hadn't happened. The business was driving negotiations for what was a very profitable contract. And inevitably in those situations, some of the rigid rules that might ordinarily be applied get watered down. And as a result, legal has a hard time getting the terms they might have liked to rely on in agreements with suppliers. The security team might have very little to do with onboarding the supplier and checking the various security terms and requirements in those agreements until certainly in the incident that I'm describing years later, there were a bunch of complaints prompted by an audit. That prompted an audit, but then subsequently identified a host of security concerns. And unfortunately, they didn't get around to addressing those before the pandemic and a subsequent ransomware attack that impacted dozens of my clients' customers worldwide. So I don't think, Wim, that I think you'll agree, anyone needs persuading of the importance of good onboarding processes and the importance of audits. But can you talk to us perhaps about some of the other problems that can stem from incidents like the one I just described? And in particular, you touched on regulatory consequences for inadequate processes and measures and so on.
Yeah, so look, I think one thing not to forget is if you are, under scrutiny by the regulator for purposes of a breach, and whether that's as a result of maybe a supplier that jumped the gun and already reached out to a regulator, and then you had to quickly follow up on that and submit your own notification. Supervisory authorities in Europe, again, tend to also increasingly look at your overall GDPR compliance, and something not to forget, because you may implicitly be drawn into a much larger investigation as a result of the actions of your supplier. Right, and so you then need to ask yourself the question: okay, we're going to notify here, or it has already been done on our behalf, basically by the supplier. But do we have all the basic compliance in place? That might sound self-evident to all of us here on the call, but in practice, it's not always the case. And so, are you then ready to deal with this larger fallout that could come out of the breach notification? I remember a couple of years ago there was a case involving a Belgian telecom that notified the breach to the Belgian Data Protection Authority, who decided to, investigate the company's overall compliance with GDPR. And they found that there was an issue with the internal DPO, the Data Protection Officer of the company, who apparently had a conflict of interest that the company should have known about and should have avoided in the first place. And ultimately, that company was fined for that particular violation of the GDPR, right? So again, bear in mind that could happen. That is not just going to be about the breach.
And what's also interesting, and what is evident from industry surveys, what's consistent is that even though we lawyers built these audit and inspection rights into these agreements with suppliers, that our clients are not enforcing those rights, and very often those audit rights aren't exercised, and so that is a challenge, and that all predates the actual incident, and we should make use of the rights we have built into these agreements with suppliers.
Jarno, do you think part of the reason for that stems from that trust and goodwill component that you're describing? And does it by exercising an audit right, does it suggest to the supplier that you don't trust them?
No, I don't think it's the case at all. We as customers are just making sure that we deal with reliable parties, and it's not about trust, it's about our regulatory obligations. For example, we want to make sure that we want to build an environment of cooperation with our suppliers. That part of that cooperation is that we are allowed to exercise our contractual rights.
Yeah, absolutely. In addition to some of the regulatory consequences you were describing on the personal data side, Wim, it might be helpful to talk a little about the now overly complex additional regulatory notifications that you might have to make. And I'm thinking in particular where you might have operators of essential services, where you might have cybersecurity obligations, where you might have financial services obligations, and so on. What's been your experience in terms of how they mesh together with those already very strict personal data timelines?
Yeah, again, James, at least in Europe, the problem is that there has not been a lot of efforts to streamline those different notification requirements. So if you're in one of those sectors, or if you're providing one of those services that's covered by these specific regulations requirement, it can be quite difficult to manage in practice. Also because you're not always dealing with the same regulator, depending on the country. So there's some differences there as well. and forget about the concept of one-stop shop, right? So you end up with numerous different notifications to different regulators with different timelines. So that can be quite difficult to manage in practice.
Yeah, definitely. And Jarno, that must be something that features in the US as well, when you're thinking about notifications just beyond data privacy.
Yes, I mean, the SEC introduced a 48-hour notification obligation to investment advisors and business development corporations. It did not include publicly listed corporations yet, but I think we're heading into that direction.
Mm-hmm.
Many sectoral regulators are now introducing notification obligations on cybersecurity incidents, and obviously that doesn't just limit itself to personal data breaches, but then also broader breaches of company systems.
Definitely.
I think now they're also encouraging openness in terms of discussing with regulators incidents experienced and kind of lessons learned. So it's kind of a two-way street, hopefully, there as well.
I hope. I'm always a little skeptical.
Right.
So you touched, Jarno, just on DD processes and auditing. Can you maybe just expand on diligence that ought to be happening prior to onboarding and the importance of that diligence, and frankly, the importance of getting it right?
Yeah, and so obviously it has to be the whole team, not just legal, not just technical, not just business development, not just the buyer procurement units. It has to be the kind of a combination of all of those teams working together, engaging suppliers, and making sure that the supplier has a similar team in place to kind of, for example, the legal obligations on one, but then we lawyers aren't the best, or although some of us might be, but the lawyers need technical expertise as well, and we need to cooperate between the technical team, the legal team, the compliance team, to have a full understanding of not just the regulatory obligations, but the actual information security risks involved in engaging a specific supplier. And that's a critical element, that we work as a team together.
Yeah, because unless you're really cataloging the risk, how on earth can you hope to understand what it is and address it, right?
Right.
And then, and Wim, just thinking about the importance of diligence again, and you mentioned broader regulatory investigations. If you lack those adequate diligence processes, Jarno's super diligence process, what can we expect from a regulator? What sort of a ticking off, if at all?
Yeah, James. So again, from a GDPR perspective, the due diligence aspect is not just a best practice, it's actually a duty under the GDPR, because as a controller, you have a duty to select only suppliers that are trustworthy and that can process your data securely, right? That's an obligation in the GDPR. So if you have a regulator that finds that your breach could have been avoided if you as the controller had conducted proper due diligence on the processor, that could constitute a violation of the controller's data security obligations under the GDPR, right? Because again, this is a principle that's often forgotten, but as a controller, you remain responsible for the data handling by your processor, provided that the processor does not neglect your instructions, does not go beyond those instructions, right? But you stay responsible no matter how sophisticated or how large the supplier or the vendor is, right? There's just no excuse. You stay responsible, even if in practice it's very hard to, as a controller, to control the actions of your processor, right? So it's kind of an impossible task in the law, but it is, it is in the law, and we can all agree that it's essential to have adequate due diligence processes in place. What that means, I think, also depends, on the specific processing. I don't think there's a one-size-fits-all here, but I do think it should be a condition sine qua non for every supplier that you're onboarding. That there should be no excuses as long as that supplier is going to be touching on your personal data, handling your data, and I think, James, it should go much further beyond just asking your supplier, hey, can we get a copy of your technical and organizational measures, right?
Right, or your SOC 2 or something, yeah.
Yeah, you want to really make sure that you understand, how they've been handling breaches in the past, that you also carefully review their incident response plan and make sure that it aligns with yours. I sometimes surprised to see that clients do not always have that reflex, but if you're trusting your data in the hands of a supplier and there is no coordination on basic security, then that's probably an accident waiting to happen.
Yeah, and that's an interesting point you've made as well about essentially negotiations over where the risk should fall, and just thinking about some of the players in this space perhaps for a minute, and to what extent, if you come across clients who think that they perhaps don't have the ability to negotiate the terms that they might like, do you get stuck at that point, or would you say to clients, well, there's nothing you can do, or what is the strategy there?
Just a quick note there, James. Helpfully, though, some of the larger players in this space that are not to be named, they typically have considered cybersecurity and information security in their offerings, and they typically have their certifications, they have their ISOs, they have their SOC Type 2.
Yeah.
But smaller vendors, obviously, this becomes a challenge, but then there is no leverage issue. So, but again, we kind of can get a bit more comfort that larger vendors have typically considered information security in their offerings.
Yeah, James, in my experience, particularly the larger vendors tend to happen what they would probably consider default position, which is the one they will put forward whenever they enter into an agreement with a new customer, and that's their preferred position, obviously, for obvious reasons. But typically they have optional positions as well, and it's a matter of exploring, what are your concerns, and then to what extent does your supplier actually, or is in a position to cater to those concerns.
Yeah, right. Absolutely. It's a conversation. Again, like I think, the point that Jarno makes about, it being an open relationship and it being trustworthy, or to build that trust rather, is key. And if you feel ultimately you can't have those conversations, it can be very difficult to build that trust.
But one thing I do want to point out, though, is that if you are a large customer of a large vendor, do use your power and your leverage and negotiate with your large vendor.
Absolutely. Thinking perhaps just a little further ahead and other potential consequences outside of regulatory, inevitably what you're seeing a lot of now, certainly I'm seeing a lot of, is satellite litigation or follow-on litigation from these breaches, where essentially from all the costs that flow, folks feel that other people need to pay, and wherever those costs may fall tends to end up in the courts, or at least in some fairly angry correspondence. Is that something that you guys are seeing more of nowadays, claims between customers and their suppliers, or does it tend to get resolved through discussion in the spirit of that trust and the open relationship?
You want to start with that?
Yeah. So, James, in my experience, mostly the latter. So mostly through discussions and trying to come up with some consensus. Again, referring to your earlier point about trust, I think in those cases, even if there's been a serious breach, that most companies will still try to continue with their current supplier, given the large investments that have been made initially.
Yeah, large investments that are longer term, right? It's very much an ongoing relationship, and frankly, backing out of something like that can be very complex.
Yeah. And the farthest I've seen mostly going is to make use of the mediation process in the agreement, not going to court.
Okay. All right. I want to change gears a bit and talk briefly about international supply chains, or frankly, it might as well just be called supply chains nowadays, given how often it does seem to be just international. Certainly, I'm struggling to think of a recent incident that hasn't involved more than one region on some level, and then you're dealing with those multiple regulators, laws, and reporting requirements that we've discussed. Jarno, I know beforehand you had mentioned a couple of isolated cases and some interesting edge cases when it came to international thinking, but maybe if you could just sketch out what the landscape looks like in a typical breach, and then talk about those. Yeah,
sometimes we tend to forget that in some jurisdictions, at least, there may be criminal liability implications to lax information security, and so, for example, right now, there's a what is apparently the largest criminal investigation in the nation, in terms of number of criminal complaints filed, is this data breach that impacted this online therapy service in Finland. And 3 of the company's information security team members have been now indicted for criminally negligent, rather, I should say, handling of information security and data protection in the organization. And suppliers have been investigated, and we just sometimes forget that there's also potentially criminal implications. But what was interesting from the statements that came from the law enforcement there is that they really dug into the sort of the information security culture in the organization and the lack of that culture in the organization.
Yeah, and yeah, like you say, the criminal element of it. I mean, as if any incident response forum really needs us to scare them more. But like, can you? I mean, just is that law? It just applies within Finland? How does that work? Is it, in terms of just thinking about jurisdiction? So, are you talking about individuals who are located in Finland, or is there a broader jurisdiction to it?
I'm not a criminal attorney, but I'm sure there are similar laws in many nations that kind of have, the criminal codes have sections around information security. And so there are probably similar laws elsewhere. I don't know what the situation is in Belgium.
Yeah, Jarno, I'm also not a criminal lawyer, but I think there are ongoing efforts in Europe, at least, or at European level, to indeed create more criminal consequences, criminal law consequences. And as a matter of fact, in the most recent proposal for a Cyber Resilience Act that I think was launched last week or a week before by the European Commission, there's discussions around the possibility for criminal liability, and also in the NIS2 directive, which was on which there is a political agreement now among the European institutions. For critical sectors and digital services, there are now provisions, apparently because the final text is not out yet, but that would hold top management of companies accountable, for non-compliance with these new cybersecurity rules. So, it's becoming more serious, and even I think in those jurisdictions where currently, there's no direct liability for, let's say, for management, that is probably going to change in a few years.
Yeah. What are some good strategies that you've seen work in terms of really tracking the types of obligations that you might be subject to? Because of course it's not just regulatory; you also have contractual notifications to your end customers, perhaps. So, what in terms of processes and good systems, what have you seen that works, and perhaps what hasn't?
I don't think there's a silver bullet, James. There's not one particular method that works, because it depends on the sophistication of your data processing activities and the supplier as well. I think you just need to do a lot more hand-holding with some of the smaller suppliers. But as Jarno pointed out earlier, I think it's a question of just putting that down in writing very carefully up front.
Yeah.
Yeah, Jarno, have you seen it go wrong? Have you got any war stories around just poor record keeping, or perhaps poor processing, poor processes, sorry, in terms of tracking exactly what obligations you might have in the event things go wrong?
Yes, I have. To answer the question, but obviously, some of these obligations, like for example, GDPR record of processing activities and things like that, we're still seeing organizations that haven't built those, and there's no fully awareness of where data resides in those organizations, and no proper data mapping has been done, even in some of the more mature organizations. And then there are legacy systems that some of the team members may not even be aware of, and they carry their own vulnerabilities. So it really comes down to taking the time to properly map and record what it is that what data you have, what customer data you have, where does it flow. And it's just something that companies should do, but they don't take the time to sometimes do it.
Yeah. I mean, like I was going to mention or ask you about legacy systems, and in particular, I can't count the number of times when I've seen mergers that just haven't really gotten a handle on the existing perhaps body of agreements, or folks haven't been moved on to new terms, and inevitably the folks perhaps have left the organization and nobody quite understands what diligence processes were done, or why they're on these particular terms. And getting a handle on that when you're trying to deal with a crisis can be a real headache, and divert a lot of resource away from certainly the everyday function of the business, but also getting on top of the problem. Has that been your experience, Wim, as well?
Yeah, absolutely, James. And I think another complicating factor is that increasingly suppliers are using a myriad of different subcontractors, sub processors basically, and either as a controller you can agree with that in a general way, or require specific authorization where you would want to see upfront a lot of details around the subcontractors that will be handling your data, and also in which locations they will be processing and keeping your data. But unfortunately, that is not always the case. I think the overall theme here is that often the customers will take the position that they're dealing with a sophisticated supplier, so that they must be getting it right, and there's no need to look into that level of detail, right? Where, again, coming back to my earlier point, if it does go wrong, you don't have an argument vis-a-vis the regulators. You can say, we should have asked about the subcontractors, but we didn't because we thought we were dealing with a very large supplier and we thought everything was fine, when it turns out that was not the case.
Yeah, and on that note, by the way, it's just an interesting observation that when you encounter, particularly in the digital services and data analytics space, there are oftentimes the processors or the vendors often don't have their own information security, but they rely on their own sub-processors, contractors' information security that is particularly a brand name company that is a large cloud vendor. And sometimes then you have a conversation with a client whether they're comfortable with relying on the subcontractor's information security as opposed to the actual supplier's information security. And that may be a challenge, and it really comes down to risk appetite and comfort level with the supplier overall.
Yeah. And Wim, is that the type of thing that a regulator is going to be satisfied with hearing, do you think, in Europe, where we have slightly stricter, perhaps, standards?
Yeah, again, James, I don't think they will, right? I mean, I think they'll expect you to do your due diligence also with regard to subcontractors, and to make sure that, for example, if you're relying on subcontractors outside of Europe, right, that they're also bound by the proper contractual safeguards through passing on standard contractual clauses, for example, and that's all done, including, and again, this is something that my experience is still often forgotten, including doing the necessary transfer impact assessments, right? Especially when we're talking about jurisdictions that don't benefit from an adequacy decision from the European Commission. Now, again, this is something that you can all discuss with your supplier, but I don't think a lot of suppliers will actually volunteer that type of information until you actually raise it with them.
Yeah, well, especially, I mean, it'd be interesting just to dive into that for a minute or two, the international transfers element of it. I mean, but especially when there's so much uncertainty about it, right? I mean, for some of these big name suppliers, trying to set out their flag as to how exactly they deal with these international transfers, really in the absence of any real guidance, or at least guidance that is functional, very difficult.
So James, since Wim mentioned the transfer impact assessments, it's been a thorny exercise for many. And so, for example, just to illustrate the kinds of issues you encounter, we send an impact assessment form to a vendor in Asia, and the Asian vendor simply responds, "We have no such laws." What do you do with that information? Then you're going to have to second guess and maybe retain your own local counsel to kind of do the assessment on the vendor's behalf, so to speak, and who assumes the legal costs in connection with that type of exercise. And it gets complicated very quickly.
Yeah, James, I think it's a great point that Jarno raises about the cost element of it, right? Because if you have a supplier that is using subcontractors in various jurisdictions, and they haven't done that previous, I would call it, homework around transfer impact assessments, then what do you do as a controller? Do you, engage local counsel yourself and do all these transfer impact assessments, which can be quite costly? Or is there some way to ventilate those costs back over to the initial supplier? I mean, it's not a discussion that people like to have, but it's probably something that you should discuss up front.
Yeah, it sounds like a pretty big red flag as well in terms of to your earlier points about, can you trust the supplier? Does it really have the suitable security requirements, both under the law, but in terms of just satisfying your own customers that you're doing the right thing? That seems like a pretty big red flag to me.
Yeah, and then also from in some jurisdictions, for example, an element of the transfer impact assessment is that whether the local authorities actually enforce the laws as they're written. And some local council are simply unwilling to second guess their national authorities and how they would enforce the laws differently than they're written. And so that gets challenging also pretty quickly because you can't get answers.
Yeah, in terms of just a practical application, perhaps of some pretty complex laws, when and again in the vacuum of any real guidance or case law, yeah, something we come up against time and again. Okay, we've only got a few minutes left. I just wanted to touch on what's on the horizon briefly, and then we'll finish on a takeaway each, perhaps just in terms of what we'd like folks to remember from this session. In terms of horizon scanning, then, just perhaps starting with you, Wim, what is on the horizon, do you think, for the next 12 months in terms of what people need to be thinking about when it comes to supply chains?
James, I think, we already mentioned it, right? The NIS2 directive, which is the successor of the first NIS directive, which was already outdated after a few years after being launched, basically. But is now going to cover more sectors, more digital services, and hence cybersecurity requirements. I mentioned also accountability for top management. So in other words, a much more stringent regime we're going to be seeing, and also it'll have an impact also in terms of reporting with, according to the European Commission at least, streamlined procedures. But again, we will need to wait for the final text to see what that actually means. Recently, the European Commission also launched a proposal for a Cyber Resilience Act. So interestingly, where the NIS2 directive focuses on services, the Cyber Resilience Act addresses products with a digital element. Now, that's a very wide concept. It covers a range of products ranging from baby monitors to smartwatches. So basically everything we're using these days, I would say. And interestingly, it imposes an obligation on manufacturers and developments of those type of projects to apply cybersecurity by design in their products. And they also need to be transparent around that. So I think it's going to be interesting from a breach notification perspective, right? Because I think it means that in the future, customers of these projects will have to make sure that this new Cyber Resilience Act is being complied with before they start using these products, for example, for processing personal data. So that's all waiting for us, James.
Sounds like a headache. Jarno?
Just continuing on the theme that we're going to see in the US, we're going to be seeing more and more of these sectoral notification obligation laws come in out of the legislatures, both at the federal and state level. And we're seeing increased statutory requirements on what supplier agreements need to include in terms of personal information protection, and really just more regulation on the horizon.
Fantastic. And then in the very brief time we have left, perhaps just a sentence in terms of your one away from today, please, gents.
My 2-year supplier due diligence, build an environment of cyber secure operation with your suppliers, and exercise those rights of audit and inspection.
And Wim?
Make sure that you have some sort of supply chain risk management in place, which is based on a zero trust model and which adequately is reflected in your contract with your suppliers.
Fantastic. Thank you, gentlemen. Bruce, back over to you.
Thank you, James. Great job moderating. And Wim and Jarno, thank you so much for your insights here today. It was a terrific panel. We will be moving on to our next panel in 5 minutes. It's a national security focused panel, the U.S. perspective from John Carlin, DOJ in the United States. Back in 5.